Hey everybody, welcome back to the channel today. We've had some big punches rolling and they are going to keep coming. We've got some more good news for you today. With us here in studio to deliver it, we have a partner at Michelle & Associates, Josh Dale. Josh, thank you for being with us on this today.
My pleasure.
So what we've been hitting lately, and I want to hit again today because we did see the decision come down on the 19th, was our lawsuit, South Bay Rod and Gun Club v. Bonta. This is the one we made a video about Bonta actually kind of bowing out of the lawsuit, saying, hey, this is unconstitutional. I can't defend this law. Gavin Newsom ended up coming in and saying, hey, I want to intervene on this and have my attorneys come and argue it. At that point, we were kind of wondering, what Judge Benitezs was going to allow, whether he was going to allow Newsom's attorneys to do this. But then he drops this decision on us, which is good. And I wanted to read this because I don't know if he was trying to be funny, but I think it's kind of funny. He started out his decision by saying, hey, it's cynical, it's an abomination, it's outrageous and objectionable. There's no dispute that it raises serious constitutional questions. This is a quote from Gavin Newsom on a similar law, SB 8 in Texas. So I'm just curious in this decision to ultimately give us a permanent injunction on this. What's the background on it? One more time, what's the law and what exactly does this injunction do for us?
Okay, so what this law is, as you mentioned, it's a copycat of SB 8, which was the law that was passed in Texas to ban abortion. And it had two components. The first component was the bounty law aspect, which allows individuals to sue abortion providers and those who assist people in getting abortions. The second aspect of that law was a fee-shifting provision, which basically said if you tried to come in and challenge that law or any other abortion restriction in Texas, you have to pay the state or the local government's attorney's fees unless you prevail on every aspect of your challenge. So that was the Texas law. Governor Newsom expressed how upset he was. AG Bonta expressed how upset he was. The legislature followed suit, and they said, well, if Texas can pass this law with regard to abortion, we're going to pass the same law with regard to firearms restrictions. And that's exactly what they did. They took the law from Texas almost word for word, changed the word abortion to firearms restrictions, and that was what we were faced with. So with the CRPA, with other groups, we went ahead and we filed a lawsuit challenging the fee-shifting portion. And the reason for this is this is something that was chilling our ability to challenge all these new gun laws that have come into effect since the Bruin decision came down. And it was important for us to get out there and see whether or not we could get this thing enjoined. Because we have a whole bunch of lawsuits out there and we have a whole bunch of plaintiffs who want to participate, but they are genuinely scared that if they were subject to this law, they'd lose their house, they'd lose their retirement, they'd lose their car because, as good as we are as attorneys, as good as other attorneys may be that are litigating these types of cases, we can't necessarily win on every single claim that we bring to challenge a gun law.
Well, I think that's an important distinction to make just because what that really means is that with this provision in our law, we can't really move forward with any of our other lawsuits. So it was imperative that we struck this from is it civil code?
Code of Civil Procedure.
Code of Civil Procedure, that we struck it from the Code of Civil Procedure so that we can continue and move forward with our other big lawsuits like Duncan, like Rhodey, like the Boland. Any of these other lawsuits that we have, we needed to get that out of the way. I thought something else that was interesting in here, Judge Benitezs went into, because what he gave us here was a permanent injunction. We've seen an injunction before. That's a term that we use pretty often when we're talking about lawsuits. But in the Duncan case, for example, the injunction that we got, which gave us Freedom Week, it didn't mean that Judge Benitezs was done hearing the suit. This one seems to, but specifically for the permanent injunction, it reads here, the plaintiffs have satisfied all four factors needed for entitlement to a permanent injunction. Can you tell me generally what the court looks for in order to satisfy four factors to get a permanent injunction, and what a permanent injunction in this case actually means as far as the Southern Section Court?
Right. So when you're asking a court to enjoin a law or enjoin an act, there's a balancing test they do, and the four factors that Judge Benitez is talking about are the four factors related to that balancing test. So they want to look at what's the harm being alleged against the person who's seeking to stop the law. And in this case, we showed the harm was huge. It was stopping the filing of lawsuits. It was causing plaintiffs to drop out of lawsuits. It left current plaintiffs in cases like Duncan and Rhodey scratching their heads as to, well, if I continue with this lawsuit we're almost to the end of it. You know, we've gotten to the point where we've gone all the way up to the Supreme Court. We've come back down. It looks like the finish line's right there. But what's the effect with this new law if I continue to stay in? What's the effect if I drop out right now? Am I conceding a loss to the state such that I'm going to be called to pay personally the attorney's fees and costs of the attorney general? So the court looks at that sort of harm. It also looks at, well, what's the state's interest here? And that was the amazing thing about the hearings and the briefings on this particular law, was that in all of the arguments that both the attorney general initially made before he bowed out, and then Governor Newsom's lawyers made, they never identified a state interest. Their state interest was essentially, well, if Texas can get away with it, we should get away with it too. And that's not really a valid state interest. A valid state interest is we need to protect safety. We need to protect this particular population. We need to advance some clear policy goal of the legislature. They basically said, we're going to do this tit for tat. If Texas can get away with beating their wives, Californians should be able to get away with beating their wives. It's a ridiculous concept, but one, unfortunately, here that the state decided to pursue as long as it did.
Well, I thought it was important, and correct me if I'm wrong, I'm paraphrasing here, but basically what Judge Benitez did when he was breaking down those four criteria is explain that this law was creating damage to a constitutional right of the people in California. Is there a difference here? I mean, you have a law in Texas, and I understand we've had Chuck on, and he said that this portion of SB 8 he didn't even necessarily agree with. But when it comes to Gavin Newsom making this argument of an abortion law versus, attacking our Second Amendment right in California, one is constitutionally protected and one isn't. Am I wrong on that?
That's definitely one way to look at it, and it was certainly the subject of some of the oral argument that particularly the questions, the very pointed questions that Judge Benitez put to the governor's attorney. But I don't know that there's necessarily an answer as to whether or not an attack on SB 8 or an upholding of SB 8's fee shifting provision does or doesn't have an effect here. Because yes, you're pointing out the argument. Abortion is currently not protected under the Constitution per Dobbs and the whole women's health line of cases. But and with Bruin, obviously, there's an enumerated civil right with regard to firearms. But this is really about access to the courts. And this is what makes this a nasty law. And as Judge Benitez rightly pointed out, when you stop letting people have access to the courts to make good faith challenges to laws, whether they're constitutionally protected or not, when you say we're going to punish you for even raising the question, you create a situation where people feel powerless and they feel as though the rule of law no longer exists, and then they take the law into their own hands. Right. So I think there is potentially a colorable argument that what California did here was worse in terms of civil rights because of the differentiation between a Second Amendment right versus this unenumerated, and now disfavored alleged right. But I still think with regard to both, you're treading in very dangerous waters. And we were certainly unhappy, not just because of the effect it was having on Second Amendment cases here, but in general, that Texas even passed this law, because it creates this issue not just for the Second Amendment, but for every other civil right. You're inviting states to do stuff like this.
Well, I think Judge Benitez did end up kind of highlighting what you're saying, in his final order, where he says the court declares California Civil Code 102111 to be unconstitutional and permanently enjoins the defendants from bringing any action or motion under 102111 to obtain an award of attorney's fees and costs. Therefore, it is hereby ordered, and here it is, folks, that Defendant Attorney General Rob Bonta and intervener defendant Gavin Newsom are enjoined from implementing or enforcing California Code of Civil Procedure. This is a permanent injunction. So, Josh, I want to touch on Gavin Newsom's response to this order, but just to round this out, this is a permanent injunction. In your opinion, does this get appealed to the Ninth Circuit, or does it stay here?
I wouldn't be surprised if it gets appealed. I think, and I don't want to climb into Governor Newsom or the Attorney General's head, but I think they really want to try to use this as a contrast to SB 8 and the current SB 8 litigation that's going on right now in the Texas federal court. And so I believe they probably see some advantage in appealing this, even though we're about to talk about the statement that Governor Newsom came out with, which was a bit 1984-ish when it came to their efforts to stop us and to stop the Miller 2 plaintiffs from getting this law enjoined. But I see that there's potentially an appeal. Now, unlike Duncan, if I were to bet money on it, I would guess that you're not going to see a stay of the injunction either granted. I don't believe Judge Benitez would grant it like he did in Duncan, but certainly I don't think the Ninth Circuit is going to issue an emergency stay to stop the injunction while it's being appealed by the state. So I think that's going to be different. So I think we're going to be in a position where this law is not in effect for some amount of time, even if the Ninth Circuit at some point decides that they disagree with Judge Benitez.
Well, I guess best and worst case scenario. Best case scenario is it doesn't go anywhere at all, and that's just the final answer. Or, if that ends up being the worst case scenario where the injunction stays intact while it continues to be litigated in the Ninth Circuit, that's definitely something that I would take. I think that we have a winning argument here, so that's good. But here's what really, and excuse the language here, but this is what really kind of pisses me off. Gavin Newsom, Jacob, if you can, just put the entire thing on the screen here for everybody to see. I want to focus on the second paragraph here, and it reads like this. I want to thank Judge Benitez. We've been saying all along that Texas anti-abortion law is outrageous. Judge Benitez just confirmed it is also unconstitutional. The provision in California's law that he struck down is a replica of what Texas did, and his explanation of why this part of SB 1327 unfairly blocks access to the courts applies equally to Texas SB 8. There is no longer any doubt that Texas' cruel anti-abortion law should also be struck down. So that's essentially Gavin Newsom's statement. I feel like there's actually a lot to unpack here. Obviously, he's trying to spin a loss that he just took into something positive. But I got to tell you, when I read the first couple sentences of this quote, all that I see is Gavin Newsom, and I've said it before, this was spiteful legislation turned into spiteful litigation. This is essentially our governor saying, or not even saying, admitting, I knew that this was unconstitutional when we created the law. I knew it was unconstitutional when we signed it into law. I knew it was unconstitutional when I asked our AG to defend the law. And now that you guys have beaten it back, I'll admit, it's unconstitutional, but hey, Texas is unconstitutional too. But I got to tell you, when it comes to California laws, I don't really care about Texas laws. Texas does what Texas does, and they abide by their laws, but we abide to ours. Am I wrong? Are we just pawns in a game that Gavin Newsom plays with the laws in this country?
Well, I don't think anybody thought that once Gavin Newsom became governor in California that it would get any easier for folks who support the Second Amendment and firearms uses. But I really think he crossed a Rubicon with this particular law because, I was born and I grew up here. I've been here now 47 years. And I will tell you that I've always known California as a great protector of civil liberties. We have we've been considered a bellwether state when it comes to civil liberties. We certainly don't look at states like Texas or others and go, we want to copy their law. In fact, if you look at Governor Newsom over the past several years, he's made a lot of political capital by trashing Texas and trashing Californians fleeing to Texas and other states. And so the idea that he picked this particular nasty, awful law from Texas and said, hey, well, Texas is doing that, we ought to do it here too. I think is pretty ironic. But this is face saving on his part. This is obviously face saving. If this was a genuine expression of his position and the position he would have instructed the AG to take in order to prove that somehow this is unconstitutional, then he wouldn't have opposed our preliminary injunction motion. They wouldn't have gone through the machinations of first sending the AG in, and then later, when we essentially threatened the AG that they were taking these inconsistent legal positions and they could be subject to sanctions. When the AG bowed out, the governor wouldn't have come in and intervened in the way he did. So this was using California taxpayer dollars to see how far he could go with pushing a law that helped him with a political agenda that's anti-gun. And I find it very frustrating as a Californian because, look, I think the playing field should be as fair as possible. California has, over the years, tried to level the playing field, particularly for the little guy. And this is the most anti-little guy law that I've seen come out of California in a long time.
Well, hopefully we can get back to that, and while we're getting back to that, we can restore some of our Second Amendment rights along the way. Josh, I want to thank you very much for coming on and taking the time to be with us here today.
Thank you.
And if you like watching these videos with content on litigation and legislation that we're fighting for Second Amendment rights in California, please be sure to hit the like, share, and subscribe button. And don't forget to comment. We're going to be coming out with a comment video soon. We truly value your comments, and we want to see a lot more of them. So thanks, guys, and we'll see you on the next one.